Welcome to the BOGART Effect, a wealthy wisdom podcast. The following BOGART Effect podcast is intended for general information purposes only. The information discussed is no substitute for personalized investment advice from BOGART or another investment professional. Please see important disclosure information at the end of the presentation. All right. Good morning. Welcome to the BOGART Effect. This is James Bogart. I'm CEO and founder of BOGART Wealth, and Nell Cordick joining me. This is a follow-on to the estate plan podcast we did. Now, today, we're specifically going to be talking about trusts and the world of trusts. You know, and this is something I think there's just so many false thoughts and misconceptions around what a trust is, how it's implemented. You know, and I like to frame a trust mentally as it's an extension of you and it's an extension of your values, how you think. My professor in college used to like to say, if you don't trust them, trust them. And that has stuck with me forever. Yes. But why don't we, do a little reframe of the basic types of trusts? Correct. Let's talk a little bit about the parties, and then let's get into some special considerations and how people, what do you think about these?
And before we do that, I would also like to say that if you go back, probably 25 years, trusts were not as prevalent as they are today. That's the key, is that in the past, people thought of trust as being truly for the ultra wealthy. And now the way the laws have changed through the years, trusts are actually a benefit for technically anyone with assets.
Absolutely. Yeah,
and so
absolutely.
I think people need to really kind of re-educate themselves on the benefits of trust.
I couldn't agree more. And I think the utilization dramatically differs. Exactly. I would tell you that the number one misconception I see is that people think trusts are like this tax savings vehicle. And that couldn't be further from the truth. It's actually exact opposite. If there's any takeaway from the podcast, I would tell you trusts, no matter what form of them are, they're control assets,
correct?
Right? Or control vehicles, not tax conduits.
That's right.
And I think that if that's the only thing you take away from this, is that's the point, right?
Exactly.
Now,
and I think you want to think about having a trust is that you are managing your assets from the grave. And that's really, there are incapacity issues too, which we'll talk about. But truly, when you think of the future, is you can put stipulations in your trust for the future.
Absolutely.
And that's the real benefit.
Well, so let's recap this, right? So there's two types of trust, revocable and irrevocable trust. We talked about it in our previous podcast, but, revocable trust is an extension of you. It's taxed at your social security number. As the name says, it's fully revocable. You can change beneficiaries. You can change language in the trust. It can be modified at any point in time.
That's right.
Whereas an irrevocable trust, the exact opposite, right? Like I like to describe an irrevocable trust as its own entity. When assets go into an irrevocable trust, it has its own tax ID number, files its own tax returns, and whatever language is in there, it's in there and it cannot be changed.
That's right.
So why do we need trusts, right?
Exactly.
And I know we talked a little bit about it in the previous podcast, but I think it's important to emphasize here. Trusts are control vehicles.
Absolutely.
And when I think about how someone stands up a revocable trust, right? Like that is mostly for privacy, right? When we're using a revocable trust to get the assets titled correctly. But when I think about assets transitioning to the next generation or respective heirs, it's really for, again, avoid probate.
That's right.
And real quick, probate is the legal process of how assets transfer if they don't have a beneficiary designation or they're not in a trust. Probate is a very public transition of assets. And in a lot of instances, people don't want other people knowing what they have or what they've transitioned to their beneficiaries. So trusts are the best conduit to mitigate probate. And in some instances, just real quickly, probate can be expensive. Certain states, probate is very expensive. Most of the states that our clients are in, it's not a cost thing. It's mostly this privacy. But then I use trusts for creditors.
That's right.
So if someone inherits monies that has gone through probate, now all of a sudden, and especially if it's a public record, you can rest assured if they get in a car accident, it could be completely innocent, but someone gets hurt.
That's right.
You can rest assured that whatever they inherited is going to be named in that claim. I've just seen it time and time and time again. And having assets transition to your children or heirs via a trust, they're the beneficiary. They don't own them.
That's
so
right.
creditors can't come after them. Not to mention they most likely wouldn't know that they exist. There could be assumptions that assets have transferred, but they wouldn't know the actual amounts. Similar, but not the same, is divorce, right?
Yes.
So I call it the no good son-in-law, no good daughter-in-law. But if your children inherit assets and they're in a trust, they can't be named in a marital claim. So,
That's right.
And then to your point, the fourth really is for control, like
Right.
why we want trusts, and any form of trust. But we really want to be able to give guidance to our heirs on how you intended these monies to be used. I have seen every possible scenario for trust language, right? You can be very, very generous and just not have any restriction. You just want the assets to be custodied and held in a trust. I've seen the most stringent, restrictive language. Probably mine was probably the most restrictive language I've seen, but I have minor children, right? And it's a revocable trust. I'll probably change the language. But the point is that, where you can be as restrictive as you want to be.
That's right.
I also like to mention that, to me, I frame it as it's supposed to be an alignment of your values. If I had a bucket of money that I just intended on giving to my children, how would I give it to them? Probably not right. I definitely could tell you for me.
Not at 21.
But or at 8 or at 7, right? I'm not just writing checks, right? There's methodologies of how we would give that are commensurate with what I would do if I were alive, right? So I kind of think of it that way. And then from there, it's getting everything titled correctly.
That's right. And keep in mind onto that point that you think of a trust as anything that you can do today that's legal. You can also do just about that in a trust as well after you've passed away. So kind of think about it from that perspective of exactly your point. Well, I wouldn't give all of my money to my kids at 21. I may break it out over 25 years. You can do the same thing via a trust that you could do while you're living. Yeah.
And I think of, like, in my case, my kids, they have to have a W-2 or 1099 in order to be able to get anything out of a trust.
Perfect.
And again, this is where that is probably as restrictive as you're going to get, to be honest, right? But the reason for that is I don't want them to be disincentivized from working.
Right. Exactly.
And, this is a great segue, but like, this is a legitimate argument my wife and I will have because she has a different perspective and okay, right? But that's part of the nature of these kinds of conversations.
That's exactly right.
And I think it's important to make sure that it is a representation of what you believe in or what your values are.
That's right. And the important thing you just mentioned, I would say most of our clients do have differing opinions of exactly how they want their estate to be distributed. And so having that conversation is so critical to come to a middle ground of truly how you want it, because we don't know who is going to survive. So therefore, you want to have things laid out very cleanly. So regardless of who survives, you're both in alignment of what happens.
Well, let's keep pulling on my wife and I, right? Let's say I predecease her. Well, it's a revocable trust.
Right.
And while both of us are alive, it is revocable.
Exactly.
So she very simply could say, all right, I didn't like what James put in, so I'm going to change it to this.
That's right.
Now, similar, right? Like, life happens. Things change. Like, God forbid one of our children all of a sudden has a medical need.
Exactly.
And that's a great example of why things have to change, right? Like, so let's talk a little bit about the parties of a trust. And then I want to get into some of the nuances.
Absolutely. And before I'll mention just one thing that you said about I would say every single trust, every single revocable trust I've ever read probably has in there a paragraph that gives the flexibility on specific things that you're not expecting, that give the ability for the trustee to act when there is an emergency, when there is something unexpected to account for that particular situation.
I call them trapdoors.
There you go. That's perfect.
Yeah. Backdoors, trapdoors, whatever you want to describe it as. Yeah.
So people in a trust.
But hold on. In fairness, like we're joking about it, but like I have very restrictive language in my trust for my kids, but there's also provisions in there for health, education, maintenance, and support.
That's
so like the trustee could pull out for a doctorate at any point in time. It could be the most expensive college in the world. And there's no restriction because that's education.
Exactly.
Right. And that's an example, all joking aside, of one of these trap doors. But it might not fit in the normal provision or language of the trust, but there is the ability to get in there.
Exactly.
I did put it, but related to that, just because we're joking about it a little bit, but on medical, like I removed plastic surgery that was non-required, right? Like, but again, it's something that
you can put that restriction.
Yeah. And I think about like coming back to the example of like, if I were alive, if one of my children was hurt in a car accident and had a medical deformity and they needed plastic surgery, I would absolutely write the check. Right.
Absolutely.
But if they come to me and say that, they don't like something about their body, no, I'm not writing that check.
That's right.
Like, but that's a great example of how it's aligning with me as, again, my thinking as I'm alive versus if something were to happen to me and I'm not around.
That's exactly right.
It's full alignment.
Yep. So the people who are in a trust, we get back to that. The first person is the grantor. And the grantor is the person who owns the assets before they are put into the trust. So typically, if you've got a family trust, which we are seeing pretty common these days, where both a husband and wife put their assets together into one trust, technically you would have two grantors. The next party is the trustees. And so originally you have an original trustee. Typically, again, it's the husband and wife or the two spouses that are the original trustees. And then from the trustees, and also I want to add, when you've got two trustees, especially the primary trustees, do make sure that your documents say that they are able to act alone. Independently, thank you. Because that is important that they don't have to always communicate the same decision to someone.
It can't unless you want that.
But that can be very, very restrictive. And then you have successor trustees. And those are people who actually act on your behalf once you are either incapacitated or you pass away, or you just decide you don't want to be trustee any longer, and you want to appoint your successor trustee.
And then the beneficiaries.
Correct.
Right. So in most revocable trusts, we described them revocable trust, but in most revocable trusts, the grantor, the trustee, and the beneficiary are all the same person, or husband and wife.
Yes.
It's when we move to this realm of irrevocable that now all of a sudden you've got lots and lots and lots of different parties. Now, by the way, you mentioned it, but I want to emphasize, revocable trusts start while husband and wife or the grantors are alive, but they then move from being revocable to being irrevocable upon the passing.
That's right.
So now you go from being taxed at your social security number to passing away, new tax ID number, new entity gets structured with these irrevocable trusts. And now whatever language was in those documents is the language that the trustee has to follow.
That's exactly right.
So let's spend some time talking about the trustees. I know you mentioned, obviously, the primary is the primary trustee, the successor trustees, but who should be the successor trustee? Because I will belabor this conversation time and time again.
Absolutely. So most people will pick their children as their successor trustee, and that's totally fine. That is certainly an acceptable component. The only thing that I would just point out that is that if you've got multiple children or if you've got multiple beneficiaries, there could conceivably be a conflict of interest between who you appoint as the successor trustee and the other beneficiaries. So then be aware of that. They may make decisions that might not be the decision that you would have made because it could be in conflict with what they may inherit one day. The other thing that's important to think about is when you're choosing.
I want to give an example of that one. I know I used it on the last one, but we had a case where the child was the successor trustee. Mom was the survivor. She was no longer able to make decisions for herself. The child was not spending the money from the trust to take care of mom because it impacted the inheritance.
Exactly.
So just to put an actual example to this.
Yes. It is.
And that's, to me, that is not what I would want my money to be. Should be there to help for the person, right?
That's right. Exactly.
It's just because this is something we talk about so much. And I think it's really important. By the way, there's nothing wrong, as you mentioned, with the kids, but just there are things related to this that I think need to be thought through. in most instances, the wealth creator that's establishing all of this, they know what it took to create the wealth, and they know how to manage the wealth for most part. In most instances, the next generation doesn't know. They didn't go through what you went through to accumulate this, so their perspective on the wealth is very fundamentally different. Now, I've seen second generation that are way more conservative than first generation, and I've seen probably more often than not, it's the other way around, right? To have your children be the successor trustee, again, doesn't necessarily mean it's wrong, but they don't have the financial acumen or expertise that the Gen 1 has. So I think that there's an education process that needs to be put into place. And if you are going to have your children be the successor trustee, it's very appropriate to bring them in earlier than later, right? So that they know what the assets are, and you can have some of these conversations around what the intent of the assets are, especially if there's privately held businesses, if there's real estate, things that really want clarity around there. The other thing that I would say, and this is something that hits me personally, but you don't necessarily always want the kids to be the successor trustee, because if you have multiple children, that can create friction in a household that was never there before. And to your point, right, like the child might not make the same decisions you make as the trustee. And even if it's not their respective portion of the money, but it still might be interpreted differently. I'll use an example. My sister came and said she needed money for solar panels. I'm like, for what, right? And again, this was a rental property that and I'm like, that just doesn't make sense. If it was your primary, it would make sense to me, right? Like, I found myself questioning how she wanted to spend her money then, and that's not right? Like, and again, I'm in this industry as an example, right? So my point is that this is an example where kids are not always the best when it comes to being a successor trustee. And that's, there's so many countless examples of this. Main thing that I care a lot about is to ensure, and we've talked about it in past podcasts, you don't want to create friction or animosity in your household that's not there before, right? And money changes people. Obviously, I don't want my personal biases to impact the advice I give. I just know of a lot of examples where it's not, the children are not necessarily the right person to be the successor trustee.
Well, and they're also very busy in their lives at that point. You know, you may pass away and they're in their 50s or 60s and or maybe 70s, and they've got grandchildren and jobs and things like that are keeping them very busy. They may not live near where you live. And therefore, it could even become a little bit of an encumbrance to name a child as a successor trustee as well.
And candidly, I would probably also put in that same category your siblings, right? Like, your siblings are usually around the same age as you. They don't necessarily have the financial sophistication to be able to manage whatever is needing to be managed. Plus, they're probably busy. They probably have, and so now it's a burden of time.
Exactly.
Are they going to get compensated, right? Like, there's a whole bunch of questions associated with that. And this is where I think it's a perfect introduction to what a corporate trustee is.
Correct.
And so corporate trustees are companies that are put in place to be named as the successor, so that they are then going to step in upon death or severe incapacitation to be able to make decisions for the trust.
Exactly.
And so all ways, shapes, and forms of corporate trustees, I've seen them all, from banks to custodians, et cetera. I personally am biased this way. Again, this is what the route that I've gone, because I don't want to burden friends or family with managing of something were to happen to my wife or I. Excuse me, wife and I. Because if something happens to me, my wife is the successor trustee, right? Or sole.
Exactly.
No, she'd be she is a trustee. So yeah. But the point is that if something were to happen to both of us, we need somebody who's going to be able to manage it for it.
And the advantages of a corporate trustee would be really around, they do all of the filing for any particular documents that are necessary by law to be filed. They take care of all the all the tax documents that need to be filed. And sometimes that can be very complicated for a trust, because they've got to create K-1s and different things like that. So a corporate trustee takes care of all of that. They also have very well-defined responsibilities as the fiduciary to really make sure that they are handling the trust exactly as it's written and carrying out things properly. So that's also an advantage.
I would say that that same could also be a disadvantage, though.
Well, that's exactly right.
Both of us were, before we got on the podcast, we were talking about examples where sometimes the interpretation is just much stricter.
That's right.
Than what the intention of the document was. And in our shoes, we normally know Gen 1, right? Like we have serviced and worked with them, and then the successor trustee, or if it's a corporate trustee or the kids, right? Whoever it is, we then see that transition, and it's like, oh, well, that's not what mom and dad actually intended, but
it is the way it's written.
It's the way it's written, and that's ultimately what has to be administered. The other big negative with corporate trustee is cost, right? And most of them are structured where it's an assets management fee, right? So some cases I've seen flat fees, but usually it's just a percentage of the assets. But they can be relatively expensive, but I would say given the value that they're creating, it's a cost that's worth bearing at that point.
Yes.
So let's talk now a little bit about the types of irrevocable trusts, because there are. Let's talk about irrevocable trust as well as charitable trust, right? Like there's just so many different ways that we can structure these trusts outside of everything we've already been talking about.
That's exactly right. So think about, first of all, an irrevocable trust means that you want something to happen beyond the date of your death, that you want to control things for some point in the future. The first one that really is...
And I want to add to that, though, because there are reasons for having irrevocable trusts while you're still alive.
True.
And in most...
And we'll talk about some of those, yes.
But most of that is for estate planning, estate tax planning purposes.
That's exactly right.
And not to tangent too far, but the current state tax thresholds are $13.99 million. With the one big beautiful bill, we now know they're $15 million starting next year, and they'll inflate up from that point forward.
Exactly.
Prior to the bill, they were set to go back to $5 million indexed up for inflation. So the thresholds are significantly higher. So if you're over, let's just call it $28 million, then we need to start having these conversations of why we use irrevocable trust. If you're under, then you know the nuance is the irrevocable trust kicks in upon your passing.
Exactly.
Right?
That's a good point. So let's talk about a couple of those first. Let's talk about charity. So there are several types of charitable trust, and we won't go into all the details because they are quite numerous, that give the ability for you to gift assets to a trust. And you can either kind of set it up different ways. You can set it up that you receive the income, and upon your death, the charity receives the assets. And you can set it up the opposite, that the charity gets the income, and upon your death, the beneficiaries get the assets.
Yeah. So just to kind of give an illustration of that, you might want, for example, a piece of real estate to go to your children, an income producing piece of real estate to go to your children. While you're alive, you don't need the money. You've got other buckets you're living off of. So let's go ahead and put it into a trust that would then pay out to the charities, all the income that's coming in off that real estate. But upon your passing, you really want that asset to go to the kids. Okay. Or heirs, excuse me. So that's an example of where you can get really creative with these trusts to fulfill whatever your direct charitable purpose is while you're alive.
So a second type of trust that you create during your lifetime that's irrevocable would be an irrevocable life insurance trust known as an ILET. So you hear that very often. And that is basically a tool that is used for estate purposes. So an ILET is this type of trust where the trust, the trust actually buys a life insurance policy on your behalf. Typically, you gift the trust the premium every year, and the trust pays the premium on that life insurance policy to the company. And then upon your passing, when that money pays out, it pays out to the trust. And the trust is not part of your estate. So therefore, it's not included in your overall estate. But in the event that your estate goes over the $30 million, those assets are very helpful in order to cover what the estate taxes would be. Bingo. That's the whole purpose of it.
Well, or to not have the assets be counted in the math.
That's right.
So I would say anyone who thinks that their net worth is going to get over the estate tax thresholds should never be buying life insurance in their name.
That's exactly right.
They should have it in the irrevocable life insurance trust. And the reason is that all of that is not counted in the estate tax threshold. And then there's a transition that happens where it might be part of what you were describing there, where it's a liquid element to be able to pay the estate tax if you're in the position where you get up over those estate tax thresholds. One little caveat there. any life insurance that you own that you want to transfer into an ILET, there's a 3-year look back, right? So again, I come back to it. If you think you're going to be over the 30 million and you or are over the 30 million, you should never buy it in your name. You need to buy it in the irrevocable life insurance trust, and that way it's never counted there. But just be mindful, if you own it in your name and decide to transfer it, it's going to be a 3-year component. And by the way, the reason someone would transfer something they previously owned is because they might have bought it at a younger, healthier age. And then all of a sudden they've had some success that's taking them up over that threshold, or will project it to take them over the threshold. And then they want to migrate it in. It's a cheaper way of doing it.
So there are a lot of other trusts that can be designed for both a second spouse and blended families. So we'll talk about the second spouse first. So hypothetically, you have a second spouse, but no children from that union. So therefore, you want to protect your second spouse. You want to make sure that they live in the same lifestyle that you've together grown accustomed to, but you want to make sure that the assets are there to pass to the children. So one of the types of trusts that you can create for that, there's several different types. One of them is called a Q-tip. This particular trust actually creates income for the surviving spouse. However, the assets stay in place to pass to the children.
Bingo.
And the second one is basically a Q-PERT. And this particular one is a qualified personal residence trust. This gives the surviving spouse the ability to live in the residence. However, once upon their death, then it goes to the children, so that you're protecting that asset, for the children. But those are a couple of examples that are easy ones for surviving spouses.
Yeah. And to be clear, there's a lot of different ways to structure blended families, second marriages, third marriages. Yeah, I think it comes down to, it's just at the very beginning, you asked the question of what are we trying to accomplish here, right? And if protecting the children the children from the first marriage is part of something that's in consideration, then we need to structure it. If it's fully blended and you don't care, then that's a whole other conversation. I've seen those too. But it really comes down to what is the problem that we're trying to solve?
Well, and I have too. I've seen it where it's considered fully blended until the first spouse passes away. And keep in mind that the surviving spouse usually has the ability to make changes at that point.
If it's a revocable trust.
Correct. So my advice would be, have things airtight regardless, so that no matter what, that all the children from both separate marriages as well as blended marriages are protected if that is your wishes, and have the right documents created, and then have the accounts titled the proper way.
By the way, I actually think one of the best pieces of planning that we ever did, and I won't share the client name, but it was a blended family like this. You were working with them, I know this. But what we did was we had the restrictive language in place, and most of it didn't take care of the children of the spouse. And so what we ended up doing was buying a life insurance policy on the surviving spouse. And we were using the income from the trust assets to pay for, and of course living as well, but paying for the life insurance policy. So then upon the passing of the second spouse, all the kids ended up getting completely equal. That was, and unfortunately she passed away relatively early. So, but the point is that all of the children, there's 5 of them total, got the exact same amount.
That's right.
And that was an example where every dynamic is a little different.
That's right.
But this was one where it was very important to the surviving spouse to make sure that her children were taken care of as well.
That's right.
And so it was a very creative planning work that we did. And frankly, really did accomplish that goal.
Exactly.
Let's talk a little bit about special needs.
So, well, before we do that, there's one other type of trust. So what has been known in the past as an AB trust also accomplishes this. Now, it's not as common today because the estate laws have changed, but it was very common a number of years ago. But it can still be used today when you are trying to protect. And what an AB trust does is simply divides assets upon death, and one stays as revocable for the surviving spouse, one becomes irrevocable, providing income to the surviving spouse, but then it stays and passes to the kids upon the passing. So just for terminology purposes, in case you hear that term.
Well, and I think we're hitting the main ones, right? Because there's spousal lifetime access trust or SLAT. slats, there's grats, there's gruts. I mean, there's so many different types of trusts that can be structured. It really comes back to what are we trying to accomplish here? And like, I think about, I'll just mention spousal lifetime access trusts or SLATs. There are a lot of notoriety around these now. Typically, you don't see them kick in until or be utilized until households get up over the estate tax thresholds. But the reality of it is the reason that you're doing it is to get assets moved into an irrevocable trust that can still have the ability for a surviving spouse to access, even though it's out of the estate, right? So it's one where there's a lot of nuances here. Emphasis being, these are about control. These are not about taxes, right? Like,
exactly.
And so no matter how we're trying to address the problem, we want to make sure that we're looking at it holistically. I do want to talk about special needs trust, though. So in life, there are lots of examples where your children or people that are important to you have special needs that are impacting their quality of life or standard of care. You know, a lot of times you see it where you're alive, you're either doing the care yourself or you're financing the care for those loved ones. But and in most instances, there might be some government help as well, because these are disabled individuals, and you know there's grants and there's programs that are helping with covering some of that cost. But if all of a sudden that individual inherits money, well, now that can disqualify them because of the amount of assets that they have from getting any of those government programs. So the point of a special needs trust is to be exactly that, where it is a special trust, special level of care to be able to take care of your loved ones or people that are important to you that would have those types of special needs. And I just think it's important that if you happen to have someone in your lineage that you want to make sure that or you have been helping, that we do the special needs trust for them and not disregard that and have it just be a normal irrevocable trust, right?
Absolutely. And with the exact right provisions in there to do what it really is that your intention to do.
Yeah. And I would also say make sure that you have the right trustee in place.
Correct.
Because that could be an example where you want it to be a family member, but it might not for lots and lots of different reasons.
Exactly. Then we go into trusts that are designed for minor children. And we hope that this never happens, and it is a fairly rare occurrence. But anyone that has minor children should absolutely set up provisions for those children. And typically, you almost think of it kind of in two different ways. You think of one person that is appointed as the guardian that really handles their day-to-day emotional needs. They are the ones that they live with. They take them to school. They do all of the care needs that has to occur. And then you also think of a financial guardian, which would be the trustee of their trust. Now, sometimes it's the same person, but in many cases it's not. Kind of similar to, you would have different
medical person versus financial person.
Exactly.
Yeah, absolutely.
And so, but it's critical that the financial person really is at the highest standard of a fiduciary, because again, you can just see where things are tilted sometimes too far in one direction.
Well, and in that unfortunate case, like these are, I'll use my kids, right? If something happened to my wife and I, my kids are very young. I won't say their ages because of protection of them, but they're minors, and it's a long time before they're. And again, the money would be there to provide for their care, pay for their college, right? And the point being is that we want to make sure that person who's acting on their behalf. So, for example, they've got my in-laws or the guardians of them. That's their emotional care. But I'm going to argue my in-laws, I love them to death, but like the financial side would be very overwhelming for them. And so it is a separate party because of that.
Exactly.
And truthfully, that's an example where because of the standard of living that my kids have grown accustomed to, that money needs to last a long time.
That's right. Exactly. And so again, you want to put in this is not only for kids, but it's for any of the trust. Be as detailed without being too restrictive in your trust. Try to convey truly what your wishes are.
Yep. Well, and the benefit of having the language of a trust is you can have the language be different for a certain age and then be completely different. So like, for example, my children, the way that the language in the trust is written is they have a certain series of language up until the age of 25.
Yes.
We changed it. It was originally 22, moved it to 25 in case they decided to go to graduate school or medical school. And so we extended it out. But after that, the language changes dramatically. They need to go to work.
Exactly.
Right?
That's right.
It's not there to coast. And so, like, for example, they have one set of language in place to take care of their needs up until that age.
Exactly.
And then at age 25, they have to have a 1099 or a W-2 in order to get access to it.
Exactly.
Which, I know. You guys could hear me talk about how I have one perspective. It's important to me that the kids are not disincentivized from working.
That's right.
I don't want it to rob them of that experience of life. That's the way I look at it. But I think it's also important to mention that we have provisions in the trust to access, as we were talking about earlier, these trap doors, but health, education, maintenance, support, like there's other ways that they can still have access to these without just following the defined language of what's in the trust itself.
That's exactly right. And I think that, regardless of what types of trusts that we're looking at, the most important thing is that you think of what do you really want to have happen and when?
Yeah.
And who do you want the assets to ultimately go to? And then once you've gotten those answers and you're in agreement, the documents are pretty easy to be written at that point. It's just a matter of you really being comfortable with what you want to have happen.
Bingo. And I think it's important to remember, don't let these decisions prevent you from making these decisions, right? Especially if we're going down the road of revocable.
Yes.
We have to do it. I think in some of these special example cases, like special needs or blended families, not doing something has consequences, like dramatic consequences.
Yes.
And so we want to make sure that we're at least getting something done and sequencing it appropriately. And then once the documents are in place, make sure that you update the accounts, right? Like, I think that's also a very important part of this process.
Absolutely. And update when something changes with someone who's mentioned in the documents, either a successor trustee or a child or something happens to somebody, make sure that you're updating your documents upon that event.
Correct. Yeah, well, especially if something meaningful changes. All right. This was great. Thank you, Nell. I appreciate it. And obviously, if there's any questions you have for us, we at Bogart Wealth are more than happy to be a resource for you. If there's any takeaway from today, it's get the documents done.
Absolutely.
Right? So thank you all. Have a good day.
Thanks.
The previous presentation by Bogart Wealth was intended for general information purposes only. No portion of the presentation serves as the receipt of or as a substitute for personalized investment advice from Bogart Wealth or any other investment professional of your choosing. Different types of investments involve varying degrees of risk, and it should not be assumed that future performance of any specific investment or investment strategy or any other non-investment related or planning services, discussion, or content will be profitable, be suitable for your portfolio or individual situation, or prove successful. Neither Bogart Wealth's investment advisor registration status nor any amount of prior experience or success should be construed that a certain level of results or satisfaction will be achieved if Bogart Wealth is engaged or continues to be engaged to provide investment advisory services. Bogart Wealth is neither a law firm nor accounting firm, and no portion of its services shall be construed as legal or accounting advice. No portion of the podcast content should be construed by a client or prospective client as a guarantee that he or she will experience a certain level of results if Bogart Wealth is engaged or continues to be engaged to provide investment advisory services. Copies of Bogart Wealth's current written disclosure brochure and Form CRS discussing our advisory services and fees are available upon request or at www.bogartwealth.com.